Hello and welcome to Courts This Week on Live Law. I am Tanya Pandey, here with the latest updates from the week gone by. Subscribe to Live Law and click the bell icon for regular updates. We'll begin the episode with the Supreme Court judgments and then go over updates from other courts in the country. The Supreme Court on 6th August ruled in favor of e-commerce giant Amazon in dispute with Future Retail Limited over Future Retail's merger deal with Reliance Group. The top court held that the emergency award passed by Singapore arbitrator stalling Future Retail Reliance deal is enforceable in Indian law. The court held that an order of enforcement of an emergency arbitrator's award made under Section 17(2) of the Arbitration and Conciliation Act is not appealable under Section 37 of the Act. The court also upheld the order of the single bench of the Delhi High Court, which had ruled in favor of the enforcement of the emergency award, and held that single judge's order was not appealable to the division bench of the High Court under Section 37(2) of the Arbitration Act. The Supreme Court has observed that the trial of the criminal case against an Indian citizen for offences committed outside India cannot commence without sanction of the central government under Section 188 of the Code of Criminal Procedure. But such previous sanction is not required at the stage of cognizance, the bench of Justices L. Nageshwar Rao and Anirudh Bose have said. In this case, the contention of the accused before the High Court in his petition under Section 482 CRPC was that the alleged offences were committed in the United States and in accordance with Section 188 of the CRPC, sanction from the central government is required even for initiation of investigation of the crime. The High Court rejected this contention and dismissed this petition. In appeal, the bench noted that in the Thota judgment, it was held that previous sanction of the central government under Section 188 CRPC for offences committed by a citizen of India outside the country is not required at the stage of cognizance, and therefore the court was not inclined to interfere with the order passed by the High Court. While dismissing the SLP, the court clarified that the accused is at liberty to raise the ground pertaining to sanction before commencement of the trial. The Supreme Court has observed that a possible apprehension of breach of law and order cannot be a ground to detain a person under preventive detention laws. The bench of Justices R.F. Nariman and Hrishikesh Roy observed that mere contravention of law, such as indulging in cheating and criminal breach of trust, certainly affects law and order, but before it can be said to affect public order, it must affect the community and the public at large. The Supreme Court has observed that it can entertain new grounds raised for the first time in an appeal under Article 136 of the Constitution if it involves a question of law which does not require adducing additional evidence. The bench of Justices D.Y. Chandrachud and M.R. Shah observed that the principle in Order 41 Rule 22 of the Code of Criminal Procedure furthers the cause of justice by providing the party other than the aggrieved party to raise any adverse findings against them, and the court can draw colour from them and permit objections to the findings. The court held that it can, in view of the plenary jurisdiction under Article 136 of the Constitution, read with its powers to do complete justice under Article 142, entertain new grounds raised for the first time if it involves a question of law which does not require adducing additional evidence, specifically one concerning jurisdiction of the court, which goes to the root of the matter. A witness cannot be prosecuted for perjury under Section 193 of the Indian Penal Code merely because he had made inconsistent statements before the court, the Supreme Court has observed. In this case, the Karnataka High Court had ordered prosecution of returning officer on a finding that he gave false evidence before the court while he was being examined in the election petition. The Supreme Court bench of CJI N.V. Ramana and Justices A.S. Bopanna and Hrishikesh Roy, referring to the statements made by the officer, observed that it could not find any deliberate falsehood or inconsistency. The bench observed that prosecution for perjury cannot be ordered if there is no intentional falsehood uttered. Mere reference to inconsistent statements alone is not sufficient to take action unless a definite finding is given that they are irreconcilable, the court said. Once the fact of last seen is established, an adverse inference can be drawn against the accused if he fails to explain the circumstances in which he departed the company of the deceased, the Supreme Court has reiterated. The bench of CJI N.V. Ramana and Justices Suryakant and Anirudh Bose was hearing a criminal appeal arising out of a murder case from the year 1987. The trial court had convicted both the accused under Section 302, read with Section 34 of the IPC, and sentenced them to life imprisonment. The Patna High Court had later affirmed the conviction in the year 2010. In appeal, the accused contended that conviction merely on the basis of last seen theory was unsustainable. Referring to a recent judgment in Satpal v. State of Haryana, the top court observed that unless the fact of last seen is corroborated by some other evidence, the fact that the deceased was last seen in the vicinity of the accused would by itself only be a weak kind of evidence. The Supreme Court has observed that a magistrate is not required to record statement of the public servant who filed the complaint in discharge of his official duty before issuing summons to the accused who resides outside the territorial jurisdiction. In this case, the inspecting officer filed a complaint before the judicial magistrate against a company, its managing director, and others, alleging the offence of misbranding under the Insecticides Act. One of the contentions raised by the accused was that the magistrate has taken cognizance without conducting inquiry and ordering investigation. In this regard, the bench referred to the proviso of Section 200 CRPC, which states that while taking cognizance, magistrate need not record statement of such public servant who has filed a complaint in discharge of his official duties. A second appeal, after its admission with formulation of substantial question of law, cannot be disposed of summarily, the Supreme Court has observed. The bench of Justices Vineet Saran and Dinesh Maheshwari observed that once a second appeal is admitted, on the High Court being satisfied that a substantial question of law is involved in the case, and with formulation of that substantial question, the appeal is required to be heard in terms of Order 42 of the Code of Civil Procedure. In this case, the High Court had admitted the second appeal by the defendant and framed substantial questions of law. Later, the same was dismissed. The Supreme Court, while allowing the appeal, observed that a summary disposal of the second appeal by the High Court after admission could not be approved. Let us now go over judgments from the High Courts and other courts. The Madras High Court has refused to redact the name of a man earlier accused of offences of cheating and rape and subsequently acquitted of all charges from court records, while stating that there is no law in India that contemplates such a request. It stated that the right to be forgotten cannot exist in the sphere of administration of justice. The only exception it observed is in cases of victims of rape and other sexual offences, where the Supreme Court itself has directed that the identity of the victims cannot be disclosed. In a significant judgment, the Kerala High Court has upheld that marital rape, although not penalized in India, is a good ground to claim divorce as it falls in the frame of physical and mental cruelty. The court remarked that marital rape occurs when the husband is under the impression that the body of his wife is owed to him. However, such a notion has no place in modern social jurisprudence, the court found, and asserted that spouses in marriages today are treated as equal partners and the husband cannot claim any superior right over his wife, either with respect to her body or with reference to individual status. The Bombay High Court on 6th August observed that the accused in the Bhima Koregaon Elgar Parishad case, resisting the transfer out of Taloja prison despite repeatedly complaining about the prison authorities there, is confusing and paradoxical. The bench refused to stay the transfer orders without hearing the state and adjourned the matter. The National Investigating Agency has accused the civil liberties activists of being responsible for the Bhima Koregaon caste violence on January 1st and furthering the banned CPI Maoist agenda with a plot to overthrow the government. In an important ruling, the Allahabad High Court has directed that the notice of filing of bail application in every POCSO case shall be given to the parent or guardian of the child victim or complainant to be served through investigating officer or SHO of the police station concerned. The bench of Justice Vivek Chaudhary also made it mandatory for the investigating officer or SHO of the police station concerned to also include in the notice details regarding the right to legal assistance in Hindi language so as to enable them to take assistance from the Legal Services Authority. The Delhi High Court has observed that every child has the right to use his or her mother's surname and that the father does not own his daughter in order to dictate her to use only his surname. The oral observation came from Justice Rekha Palli, who was hearing a father's plea seeking directions to concerned authorities to reflect his name as his minor daughter's surname in place of the child's mother's name. After a detailed hearing, the court disposed of the petition as being without any merit. A special NIA court on 5th August refused default bail to dismiss Assistant Police Inspector Sachin Vaze in the Antilia bomb scare Mansukh Hiran murder case. Vaze had claimed that he was entitled to bail as the NIA had failed to file the charge sheet within 90 days from the date of his arrest on March 13, 2021. The special NIA court had rejected Vaze's first default bail application on June 9, granting NIA 2 months to file a charge sheet against him. Vaze was initially investigating the case. However, it was subsequently transferred to the State Anti-Terrorism Squad and then to the NIA in March 2021. These were last week's top stories. I am Tanya Pandey for Live Law, and I'll see you again with more legal updates very soon. I wish you a lovely week ahead.
Subscribe to our channel and press the bell icon to never miss a video from Live Law.